Happy Monday. I hope you're doing well out there. You know what time it is. Time for Monday Morning with Mo. Boy, oh boy, oh boy. Top of the Monday to you. Hope you're doing well out there. If you haven't joined us before, this is Monday Morning with Mo. I am attorney Mo DeWitt, and we are here every Monday morning at 8 a.m. to answer your legal questions. So if you have legal questions, you can go ahead and put them in the comments down there, or leave a voicemail at, where is it, right there? That number right there, 407-536-6737, or email us, ask@dewhittlaw.com. Hope you guys had a great weekend. We are live here from the basement bunker, whatever you want to call it. It's a beautiful weekend out there this past weekend. A little cold, but still pretty nice overall. As a reminder, if you don't know, I've said it in the last few shows, but if you do want some of those face masks, I think we still have about 30 left. So go to shop.justcallmo.com. They're absolutely free. We'll ship them right to you. And I love them. They're great quality for a face mask. Super comfortable. Best face mask I've used, frankly, but they have my face on them too, so I guess I have to say that. So anyways, thank you as always for joining us, and we're going to go ahead and get to some of these legal questions here this morning. First up this morning, we have Lewis. So thank you for the question as always, Lewis. Lewis says, my wife and I are separated. I know about continuing to pay the bills while the divorce is ongoing. What are my rights to come to my house to cut the grass and things outside? Can I go into the house? Can she stop me from going into the house? Maybe to get something that is mine that I need. All right, so we got a lot going on here, Lewis. Let me take a sip of water before we tackle this. So, for the sake of this question, I'm going to assume that you're separated. Maybe there's a divorce pending, maybe there's not. I'm going to assume that there's no injunction filed or restraining order, because if she has an injunction against you, you can't go anywhere near the house, you can't cut the lawn, you gotta stay away or you will be arrested. So assuming that fact, and you just kind of voluntarily moved out, you said, hey, I think it's better that we live apart. Sure, house is still yours. By moving out, you don't waive any legal rights. There's no such thing as abandonment in Florida. So if you move out, you don't abandon your property, you don't abandon your children if you have children together. You're certainly able to do that. So, my antennas kind of get raised a little bit by this question, because I feel like Lewis may have an ulterior motive here. If you want to go cut the grass, I'm sure that's probably not an issue. You may just want to let somebody know that you're going to show up. If you're cutting the grass at 2 in the morning while people are sleeping, you could get shot that way. It's not a good idea. Cops could get called. You want to make sure you're up front. So if you're cutting the grass, if you're helping out, nothing wrong with that. Just make sure your presence is known ahead of time and you're not causing any problems. As far as going into the house, kind of the same thing. So, yeah, it's still your house. You didn't waive any rights to it. But if you don't live there anymore, you really shouldn't be going in and out all the time. Your wife can change the locks if she wants to if you don't live there anymore. If you want to move back in, you can move back in, but, if you don't live there anymore, you shouldn't just be popping in and grabbing things. So, again, you should coordinate to go get your items if you need to. I would try to do that in one trip, not multiple if possible. Get them and go on your merry way. Now, here's a little piece of advice that I give anybody who's in this situation. Never put yourself in a position where domestic violence allegations could become a problem. So, here's what I mean by that. If things are contentious between you and your wife, you don't want to be going in there alone. Because even if something doesn't happen, all it takes is an accusation. So in these kinds of situations, it may be good to bring a friend with you. It may be good to bring a police escort with you, or call the non-emergency line of the police department in the city or county that you live in. Explain to them the situation. See if they'll send over an officer to help you out. I think it's better just to be safe than sorry in these kinds of situations. So, again, that's another reason you don't just want to be popping in and saying, hey, I'm surprised I'm here to get some stuff. And then, of course, if there's items that are in dispute as to whether they're yours or hers, if there's larger items, then that may be a whole nother issue. But sure, you can go in and get your personal property, get your clothes, all that kind of stuff. If there's stuff you need, you can certainly go in and do that. Again, just don't be doing it at 2 in the morning. Make sure your presence is known. Try to coordinate it ahead of time. And if there's any danger of a domestic violence allegation, bring a friend or a police officer if possible. So, great question there, Lewis. I always appreciate it. And if you guys have any questions out there, go ahead, give us a call, 407-536-6737. That is our voicemail line, so you can leave a voicemail there anytime during the week, and we'll play it here on the show. If you want us to call you back too, just leave a number. I won't play your phone number on the show. I'll cut that part out for you. But leave a phone number, because some people do say call me back, and then you don't leave a number, and then I can't call you back. So, anyways, let's go to the next email question here. We got Patrick. Patrick says, my child's mother absconded with my child and has been living in Georgia for the past 2 years. I previously received an order to give me custody in April of 2019, but I've been unable to get my child back. Since I have a custody order, I shouldn't have to pay child support from April of 2019 to the present, correct? So, again, thank you for the question, Patrick. Let me get a little water here. So I'm not sure what you mean by you have a custody order, but you haven't been able to get the child back. But again, I'll make some assumptions here. So I'm going to assume there was some sort of order that was, giving you custody, and maybe it was appealed and it was stayed. Maybe they can't find the mother. Whatever it is, you don't have the kids, obviously, or the kid. So in short, yes, you do have to pay child support. This is kind of one of those things that's a tough pill to swallow. Even if you're willing and able to have time sharing with the child, unless you physically have the child, typically the court is still going to order retroactive child support for the period that you didn't have the child. So in this case, I'm going to assume maybe it says she's been living in Georgia for the past 2 years. I'm assuming maybe you guys have been separated for the past 2 years. The court, even if you were to file today and it's a new paternity action, the court can go back as far as they need to and order what we call retroactive child support. So that's child support, that goes back beyond the date that the petition was filed. And they calculate that and they say, hey, the child's been living with the mother for 2 years now. You owe $500 a month for 2 years. That's $12,000. And we're going to go ahead and have you pay on that at, 20% of that per month or something. So $50 a month or $100 a month, whatever it may be. So even though you had that order, and again, I understand it doesn't really make a whole lot of sense. You say you have an order from April of 2019, but you just didn't physically possess the children or child. So unfortunately, you still owe the child support. Now, what you probably want to do is make sure that you speak to an attorney and see if there's a way to enforce that order to limit, the length that this continues to drag on. You probably should have done that a while ago, but if it's been 2 years now, you may want to explore why the order isn't being enforced. And obviously, I would need some more details on that. But 2 years is a long time to have an order out there that hasn't been enforced at all. So if you want to talk about that more, give me a call, or you can leave me a voicemail, shoot me a follow-up question. Happy to talk to you about that. But yeah, unfortunately, you're still on the hook for that child support. There's no real way around that. So there's actually someone who was asking a question a few weeks ago about a child who was about to turn 18, and the father had never paid child support, and they were asking whether it was too late to have the father pay child support. And the case law essentially says the court can go back as far as they need to order child support. Now, the one caveat to that is once the child actually does age out at 18, then the claim belongs to the child, and the parent can no longer bring that claim. So that's the one caveat to that. But they can go back as far as they need to enforce it. So anyways, next up here we have Colt. Colt says, ex-wife and I divorced in 2012. There was a custody arrangement in place where mother was primary residence for my 2-year-old, now 11. In 2017, mother had my daughter and her son from another relationship removed from her home by DCF. She was placed with me and has been since. Mother's had supervised and unsupervised visitation throughout the past 7 years, on and off due to some legal issues that she was having, like multiple arrests and such. Got it. She states that she has had her life together the past year or so, and we're trying to modify the custody arrangement. Currently, I have Monday through Friday, and Mom has visitations from Saturdays at noon to Sundays at 7 p.m. every weekend. We just got done with mediation. I'll leave part of that out. I don't want to make sure that's confidential. Basically, now she wants to flip the schedule to where she has Monday through Fridays and I get her on the weekends. I don't want to do that. My current attorney doesn't want to represent me any longer. And what do I do, essentially? All right. Again, I skipped over some parts there. So just from what you told me here, here's kind of the general rule. The judge wants the child to spend as much time with each parent as possible, meaning essentially 50-50. There's no presumption for 50-50 in Florida. But the courts want the child to spend as much time with each parent as possible unless there's a reason for them not to. And usually those reasons that we're looking at are, drug or alcohol abuse, physical abuse, multiple arrests, there's something serious going on. The other one that comes up every once in a while is just their work schedule doesn't allow them to. So here, obviously, Mom had some issues. That's understandable. The court, exercised their power, said, hey, we're going to limit your custody until you kind of get your act together. So it sounds like right now she's got her act together. So a modification of the custody is probably warranted. However, I don't see it flip-flopping. So kind of her best day in court, in my opinion at least, would be 50% custody. She's not going to get more than 50% custody just because she didn't have custody previously, because it's not a make-up time-sharing situation. If one party withholds time-sharing for an unjustified reason, then they can ask for make-up time-sharing. But here, the person who caused her to lose time-sharing is her. So she can't go back and say, now, I want, whatever that is, 80% of the custody because I missed out in the last few years. Typically what a court would probably do, in my opinion, or what would be in the best interest of the child, would be to have a graduated schedule where her time sharing slowly starts to increase as long as she continues to do well until it hits that 50-50 mark. So, if you want any help with that, give me a call. I'm happy to help you with it. We can talk about it. I'd also be curious as to why your attorney no longer wants to represent you. But to me, it doesn't sound like a situation where you would be getting less than 50% custody and she would now be getting more. Because again, most judges want the child to spend as much time as possible with each parent. And again, the court has to look at what's in the best interest of the child. If the child's been doing well and is thriving over the last however many years it's been now, they're not going to want to, disrupt that to where the child, has loses that stability, so to speak. So, that's another factor that the court's going to consider. And anything a court does when it comes to custody or time sharing is always supposed to be in the best interest of the child. So, again, Colt, want to give me a call? Happy to talk to you about it more. Great question. Always appreciate it. And if you guys have any questions, shoot us an email, ask@dewitlaw.com. Put them down there in the comments. I'll try to respond to them. I have a very hard time typing and talking at the same time, so sometimes I have to do it after the show, but I'll respond to them. Let's see. Last up here this morning, we have David. So David says, my ex-wife filed a motion for contempt against me, stating that I owe him part of the stimulus funds. Owe her part of the stimulus funds that we previously received. We were living together when we received the funds, and we spent it on bills at the time. I don't have the money to pay him back or hire a lawyer. What do I do? All right, so if you guys spend money while you're still married and living together, typically the court is not going to go back and reevaluate those decisions. So in this case, just because you received those stimulus funds, and I think it was, $600 a person on the last one, even though it was per person, if you guys spent that as marital money, the court can't go back and reevaluate those decisions unless it's what we call dissipation of assets, which is typically you're spending the money on gambling or drugs. But besides that, they're not going to go back and reevaluate those decisions. So what I would do is show up in court, making sure you show up when they have the hearing on this, explain to the judge, hey, we were living together at the time, we were still together, we were still under the same roof, we used the funds for marital expenses, and that's the end of it. And there shouldn't be any contempt there. It sounds like this is kind of nonsense anyways, but hey, maybe I don't have all the details. So anyways, I hope you guys have a wonderful week. Thank you as always for joining us. If you want some of this face masks, go to shop.justcallmo.com. We're going to try to get some new stuff up there that's cool soon as well. And have a great week, and take care. I'll see you next week for another episode of Monday Morning with Mo. Take care, everybody.